All right, it's Professor Law Dog. Time for class. Students, time for class. All right, so today we're going to be talking about uh, Miranda Warnings and the Fifth Amendment right, and what you think you know that you actually didn't know. And so again, this is going to be our first class on Miranda. This is probably going to take two parts. We will have a part one today, where we'll talk a little bit about what does Miranda mean, what do the rights mean, and then we'll talk a little bit um, uh, either Thursday or next Tuesday about custody and some of these other issues. All right, so let's go ahead and get started. All right, so so I got this kind of ghetto rigged up here right now, but I found this new program, so next week hopefully I'll be able to make the class more convenient for you with respect to seeing the videos online the same way you can see it actually on TV. All right, so the first we're going to talk a little bit about is what happened with Ernesto Miranda. And Miranda was arrested. Actually, he had a troubled childhood. Miranda was put in juvenile delinquency when he was a lot younger, locked up as a juvenile. Then when he got older, he kind of wandered around the country for a little bit, getting in and out of trouble, in and out of jail. He happened to be in Phoenix at some point and got arrested. Well, actually, the police came to his house looking. He was a possible suspect in a rape. Police came to his home in Phoenix, took him down to the police station. At that point, the young lady identified him, and he basically said that he was the one who committed the rape against her. The police then took him into an interrogation room. Two officers. They had him in there for 2 hours. They did not beat him. They didn't hit him over the head with a phone book or anything like that. But they had him in there for 2 hours, and then he came out and he had confessed. He gave a written confession. At the top of his written confession was that he had voluntarily entered. He had voluntarily confessed. He knew what legal rights was, and that he voluntarily spoke to the police. But he was never given or advised of his right to have an attorney. And so his case went all the way up to the Supreme Court. And this is the case where you hear, you see it on all the cop shows, you see it, all over the place, right? Everybody knows what the Miranda rights are. It started because of Ernesto Miranda. Now, I'm certain that when Ernesto Miranda got arrested by the police that day in Phoenix back in 1963, he had no idea that we were going to be sitting here in a COVID-19 situation where a law professor is giving you free law classes because we all shut in. I don't think Miranda understood that. But anyway, so let me explain to you what Miranda meant. And again, the court, this is mainly for me back here. But the court said, the person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent. And you heard these rights. You've heard them all the time. You have a right to remain silent. Anything you say can and will be used against you in a court of law. The reason why I think this is important is because I used to have clients all the time. They would come into my office, Attorney Lawson, the police arrested me, and they didn't read me my rights. Right? And isn't that illegal? Isn't that an illegal arrest? Hold on to that question, because I'm going to tell you why it's not. But I want to continue with what the Supreme Court said real quick. The court held that there can be no doubt that the Fifth Amendment, right? So your Miranda rights under the Fifth Amendment of the United States Constitution says that you have a right not to be a witness against yourself. Meaning what? You have a right not to incriminate yourself. That's the Fifth Amendment. And what Miranda's saying is that whenever you are in custody, whenever the police takes you in custody and they want to question you, they have to read you your rights, okay? And so when clients are coming in my office and say, I got arrested The officer arrested me, and he put me in the back of the police cruiser, and he didn't read me my rights, and he took me straight to jail. And I would ask him, well, did he ask you any questions? No, he didn't say nothing to me, Professor Lawson. He just took me straight to jail, but he didn't read me my rights. You can get me out of this, can't you? And no. Why? Because they don't have to read you your rights unless what? Unless you're in custody and they want to question you. All right, so that's what we're going to talk about today, because there's two things that's going to come out of this. Right? Well, let me tell you what else. So you have to be in custody. And once the police arrest you or put you in custody, they have to want to question you about the crime. Then, if that's what they want to do, if they want to ask you questions after you are in custody, then they have to read you your Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. If you cannot afford an attorney, one can be appointed to you, right? You have the right to counsel. That's when it applies, okay? Now, let me tell you what happened to Ernesto. He was retried after his conviction was overturned. So the Supreme Court threw out his confession. He got retried. He got convicted of kidnapping and rape. He served 11 years in prison before he was paroled in 1972. Now check this out. After his release from prison, Miranda made money by selling Miranda rights cards with his signature on them. In 1976, at the age of 34, he was stabbed to death in a bar fight. The man who was suspected of killing him invoked his Miranda rights and refused to talk to the police. He was released and never charged with murder. I mean, isn't that ironic? All right, so now, again, Miranda only applies when there's custody interrogation. So here's where all you guys who say, hey, Lawson, you talking about, you going to teach us about Miranda? I know Miranda. I seen it on Hawaii Five-0. That's on all the cop shows, man. Beverly Hills Cop with Eddie Murphy. I know all these, right? And so you think you know it. Then you telling your friends, hey, when your friends tell you, hey, man, the cop pulled me over, man, and he asked me these questions, didn't read me my rights. Do I have to say anything? We're going to go through that. It's going to take us more than one class, but to me, it's fun. I don't know if y'all, I'm going to have fun. Y'all can join me in the fun or not. Whatever's going to happen, I love this stuff. And so, again, two things before Miranda. So you got Miranda rights. Two things before they have to read you your rights. Now, can the police question you and not read you your rights? Yeah. If you ain't in custody. Right? So if a cop walks up to you and you on the corner or you down at Alamoana Mall and the cop walks up to you and says, hey, where was you at last night? And you ain't in custody, he ain't got to read you your rights. And let's say you confess. Man, I was out robbing the bank last night. That's where I was at. Where was you at? Then he arrest you, right? And then they say, hey, you didn't read me my rights. Well, you wasn't in custody. So it's two things have to happen. You got to be in custody, and they have to want to question you. And the two things we're going to go over today and the next class, actually 3 classes, because this is a lot of fun, but it takes a while, and I want you to learn it the same way that the law students here at the law school learn it. Same way. That means I'm going to ask y'all some questions, too, and see on the thing if y'all can answer it, okay? So now, I'm going to talk a little bit about the emergency exception. This is an exception where the police can put you in custody, and if it's an emergency, and I'll tell you what that means, then they don't have to read you your rights. All right, so we're going to cover that first. When are you in custody, and for some reason they can get a statement from you or question you and not read you your rights? It came out of this case, New York versus Qualls, right? The Supreme Court. Look, this guy, man, Qualls, he was suspected of committing a rape. Okay, the lady says, hey, calls the officer, the guy, I think he tried to rape me. He went into this grocery store. The grocery store was empty. Okay, the cops saw this guy named Qualls in there. Ain't nobody else in the store at the time when the police run in there and find him. When the officer arrested Qualls, he found an empty shoulder holster, right? The cop, finds a shoulder holster, but no gun in it. He handcuffs Qualls, right? So now Qualls is in custody. Remember, we just learned that. We learned that in order for the cop to read you your rights, you got to be in custody, and he has to want to question you. All right? So here, Qualls, the lady says, hey, I think he went into the store. the man that tried to rape me. They run in there. They see Qualls. Officer sees the empty gun holster, puts Qualls in handcuffs, so Qualls is in custody. Now, instead of reading him his rights, the cop says, ask the suspect, where's the gun at? Where's the gun at that's in his holster? And Qualls nods in the direction of the gun, which is near some empty cartons, and said, the gun's over there. All right, so Qualls was not prosecuted for rape. The lady couldn't identify him. And so so his lawyer comes in and says, hey, what happened? Hey, man, I went, the lady said I raped her. I was in the store. And this is what he's telling his lawyer. I was in the store, and the cop came in and asked me about the gun. And the lawyer probably asked me, so was you under arrest? He's like, well, he handcuffed me. I couldn't go nowhere. I was in custody. And then he questioned you? Yeah, he questioned me. Did he read you your rights? He's like, no, he ain't read me my rights. And you told him where the gun was? Like, yeah, I told him it was over there. So the lawyer says, well, hey, that's unconstitutional, because what the lawyer's saying is, like, I done read Miranda. If you're in custody, he's got to read you your rights. And since he didn't read you your rights, I'm going to file a motion to suppress and have this case thrown out, and then, you good to go. Right? So that's what the lawyer do. He filed a motion to suppress and say, Judge, that the Supreme Court said in Miranda that whenever the police put a person in custody and they want to question them, before they question them, before they can ask him any questions, he's got to read my client his rights, and he didn't do it. Right? And the prosecutor said, well, wait a minute. There was a danger to the public, because somebody could have found the gun. That's what the prosecutor argued. There's a danger. Somebody could have found the gun, so the cop, in a public emergency situation, doesn't have to read the person their rights. And I'm going to get to this. I'm going to give you an example where you all are actually aware of this happening and it was hidden in plain sight. Do you remember the Boston Marathon bomber? Happened a couple of years ago. And the Boston Marathon bomber and his brother set off bombs at the Boston Marathon, killing people and severely injuring other individuals. You remember that? All right. The brother died. The main person died, the main bomber, right? His brother that was still living was like an accessory to it. So the police had him in custody. Now I'm going to play, like I said, next week I got a new format that I downloaded that's going to be able to do all this stuff interactively, but right now it's the ghetto rig. This is Law Dog University, so y'all can't expect, it's the tuition free, you can't expect like high class tech devices. So hold on for a second, I'm going to play this video for you.
Anderson Cooper 360, weeknights at 8 and 10 on CNN.
Usually when someone is arrested, they get Miranda warnings, and then they have a choice of whether to answer questions or not. Here, the government has said when there is an imminent danger to public safety, they can question without Miranda warnings. That has traditionally or usually been interpreted to mean a future danger to public safety, the so-called ticking time bomb. Tell us what's going to happen in the future, and we're not going to worry about Miranda. What makes this an unusual invocation of the public safety exception is that the government is saying there is no more danger. There is no further conspirator out there. So the government's position may be somewhat internally contradictory. That's something to keep an eye on as this all unfolds. There are many unanswered questions, but that's sort of the broad outline of what the public safety exception means and what the controversy might be.
Mayor Giuliani is a former federal prosecutor. Any thoughts on that?
Well, I mean, two thoughts. First of all, it could be possible that what they're worried about are not necessarily other co-conspirators, but other conspiracies that he may know about. It may be that there weren't people directly involved in this, but his brother, having spent that much time in Russia, and might have imparted to him a lot of information about other things that are going on. So that's a possibility. Secondly, the prosecutor has to decide how important are statements from the defendant anyway. Maybe the prosecutor is pretty comfortable they're going to be able to convict him without having to use his confession, and the intelligence is worth more. So you'd have to know the internals of what they have before you can assess whether this is a sensible invocation or it isn't.
Anderson.
All right. Okay, now I'm back with you. So that gives you a good example. Most of you all remember that case because it's not too far ago. Didn't happen far that far long ago. About what that public exception is, right? Okay, now, so here's your questions. I'm going to be looking over here to see how you answer them. So assume that no Miranda warnings were given in the following problems, okay? And concern yourself only with whether the statements would be admissible under the public safety exception. So don't look at custody, right? We're not going to talk about custody right now. I want you to address whether or not the cops, when they question these individuals, can apply the public safety exception. Okay, let's see if you can get through this. All right, here's the first one. So Larry walks into a police station and cries out, "I killed her, I killed her, I killed her." The police knew that Larry's wife was missing. And so the officer says, "Are you Larry?" Larry says, "Yep." Officer, "Where's Mrs. L?" Larry, "At the boathouse." Officer, "Where exactly at the boathouse?" Larry, "In the last bay in the van." Now police take Larry, right? He's in custody, to the boathouse. They inspect the van and find a large fiberglass box, but no other signs of his wife. So they, "Hey, Larry, is she in the box?" And Larry say, "Yeah." Now, Larry, you the lawyer. Larry come to your office. They say, "Hey, look, man, they had me in custody when they took me down here to the boathouse. And he was questioning me and didn't read me my rights. He was talking about some public safety exception. But don't he have to read me my rights?" All right, now I'm going to look at y'all answers. Yes or no? Does a public safety exception apply? Let's go through. Who says that the public safety exception applies? This thing. Am I going the right way on this? Hold on for a minute, y'all. Hey, I tell you, see, I got this ghetto rigged up in here. Nelson says no. So what are you saying that that the officer does not have to read the rights, or Nelson says no. There's no public emergency, it's personal. So you're saying that the officer, he's saying the officer should have read him his rights. There's no public safety exception. Okay? All right, let's look at the answer. Now, these are real cases. The state court refused to reach the custody question, but found that all four questions were within the public safety exception. Right, so this court said that he didn't have to be read his Miranda rights, even though he was in custody, because they were looking for his wife. Now I think a lot of courts would have decided the same way that you did. And so here's what I want to say before we go to the next few problems. These judges who are deciding these cases, they always disagree with one another. So the fact that you say it doesn't apply or it doesn't mean that you're wrong. I'm gonna give you examples that really happen in court and see what your best guess is. But you could always, because here, the argument the state is making is, look, she could still be alive somewhere. We're trying to find her, and the longer it takes for us to find her, the more danger she could be in. And so we're all out on this manhunt looking for Larry's wife, and that's why the exception is there. I think a lot of courts would have disagreed and said, you know what, that's not a public safety exception, and it can't come in. All right, so here's your second problem. A suspected purse snatcher bites the officer who catches and subdues him. Right, so the officer's trying to arrest him, he bites him. The two are taken into the same hospital, the officer and the suspect, where the detective asks the suspect whether he has any diseases. And the suspect apologizes for biting the detective and offers to take a blood test. Is his statement admissible? So now let me set it up. This guy come to you and you his lawyer. And he says, look, man, I'm charged with assaulting a police officer, for doing a Mike Tyson, biting him on his ear. And so your lawyer, you say to him, well, did you make any statements to the cop? Yeah, I told him that I kind of admitted that I did it, and I apologized to him for doing it. That's kind of incriminating. And so the lawyer, hey, was you in custody? Yeah, they had me. After they arrested me, they took me to the hospital, and I was in the hospital, and I was in custody. All right. So my question to you all is now, after the cop gets bitten, and ask him this question, and the question is, do you got any diseases? Does a cop have to read him his rights first? I kind of gave y'all the answer. I hope y'all didn't see that. All right, come on. I clicked it too fast. What's the answer? Somebody has to read rights. Eric has yes, has to read him his rights. Nelson, yes, has to read him his rights. Now, let me ask y'all this. Let's say this bite happened before there was the cure to. Remember, if you got HIV positive back in the day, like in the late 80s and 90s, you could actually, in the early 90s, you would actually die, right? I mean, there was really no cure for it. So let's say this happens back then, and let's say you're the officer and you get bit. Do you think it's a public safety exception, or must you read the suspect his rights? Now let's see. Dang, Mike said, yep, rights need to be read. Nelson said, yep. Kathy says, has to still read his rights. All right, now again, this is what the court said. These are real cases. Where am I at? The court said his statement was admissible, was given in response to interrogation, but comes within the public safety exception because of the risk that the suspect might have AIDS or hepatitis. So that again, even in that situation, the court's saying you didn't have to read the rights. Let's look at our next one. All right, so follow this. A bank robber, F, is shot by the bank security guard, but manages to flee a Dallas bank. He runs from the bank. A salesman, a nearby car salesman, chases him. When F collapses in the field near the bank, the car salesman draws a gun. So now you got, good citizen has a bank robber on the ground, the gun drawn. Two officers arrive and draw their guns on the car salesman because they don't know if the car salesman is, in part of the bank robbery. And then but the car salesman lets them know who he is. The officers then aim their gun at the suspect and tell him to raise his hands and put them over his head. And then the suspect says that he's wounded and cannot raise his arms. So the cops frisk him. They ascertain that he is wounded, right? And then, but they still keep their guns on him. And the officers then ask him, who shot you? Who was with you? And where's the gun? Are the answers admissible under the public safety exception? Or should they have read him his rights? Let's go and see what you guys answered. Okay, Leo says public safety exception. Luan said yes. Yes. When you say yeah, read him his rights. Nelson, what you saying? Eric, you saying public safety exception applies. All right. Any other answers real quick? So remember, they got him in custody. He's down there. He's got his handcuffed. He's wounded. They ask him, where's the gun? Nelson says, yes, it's admissible. Look at, well, Nelson. Where you at, Kathy? Etta says, read him his rights. Nelson says, no need to advise him of his rights. Let's see. Now, here's what the courts, like I said, so, again, you can fall on either side of this. But the court said, This public safety exception applied. And what they were saying is there could have been another bank robber running around with a gun that could have killed somebody. And so they're saying, because he was still in custody, the fact that they needed to get information quick because the bank robbery just happened, he's sitting there wounded, his gun ain't there, and they're like, hey, man, where's the gun at? Who shot you? And so those statements were allowed to come in. Last one. And then we're going to go to when you get pulled over. The police arrest L on outstanding warrants. The officer notices that he's chewing and swallowing plastic bags. When she asks what's in the bag, the savvy suspect replies, meth. What a knucklehead. The state seeks to introduce the statement on the ground that the officer was concerned about the suspect's health and needed to know what he was ingesting. You're the judge. Which way do you rule? Do you rule that no, officer, you should have read him his rights because that's not a public safety exception? Or do you say, yeah, him swallowing, him chewing the bag and stuff creates a public safety emergency and you needed to know the answer? Let's see what they got. I got safety exception. Brian says safety exception. Cassie says she lost me. Nelson says don't need to advise of rights. What do you mean you lost me, Kathy? Luann Kane says yes, he needs to read him his rights. Etta says look after his health first. So I guess you mean that, okay, you don't have to read him his rights because his health, the fact that he's swallowing something that could be drugs and could kill him, the officer has a right to just ask him without reading him his rights. Ronnie says yes, for his own safety. All right, okay, here's what the court said in that case. The district court held that while concern for safety of a suspect might rise to a level where cause, that's the case that created this exception, remember, will permit questioning without warnings, it did not on the facts of this case. And here's what the judge said. The court is not prepared to base the exception on nothing more than an assumption that an immediate danger exists because the arrestee is chewing something or even because the arrestee is chewing and swallowing a plastic bag. All right, so now what we're going to do is, I'm going to skip over this one. All right, so now, you get pulled over in a car. Let's say you might be speeding or something like that. Do the cops have to read you your rights? Now, keep in mind, let me back up. Y'all going to be sitting here wanting to go over and read and get ahead of me. I can't have that now. Here's what we going. Now listen. You're on H1. Those that live in Hawaii, you're on H1, or if you're on a big island, whatever, you're on your highway. You get pulled over for speed. You get pulled over for some type of traffic violation. Now we learned earlier that under Miranda, remember the Miranda warnings from Ernesto Miranda, if you're in custody and they want to question you, they have to read you your rights. Now, I want to say this because people join late. So when Miranda was taken into custody and placed in the interrogation room for 2 hours and then confessed, that's when the court came out with the Miranda warnings, right, where you had a right to remain silent, anything you say. The reason why they came out with those warnings is this. They said, look, when you got somebody in custody and they are, being interrogated, that's a coercive environment, right? The reason why we tell the officers you got to read a person their rights when they're in custody at the police station or whatever is because, and they know that they can't go anywhere. It creates an unfair advantage, right? And because you could end up falsely confessing or because your confession may come out and not be voluntary, We understand, officers, that you have a duty to investigate and you have to interrogate. That's part of good police practice, and it's part of solving crime. And the Supreme Court was saying we want you to do that. But we also want it fair to our citizens. So in fairness, if you have the citizen in custody, right, and you're going to interrogate them about a crime, before you do, to make it even, at least to give the citizen due process, right? The 14th Amendment of the United States Constitution talks about, due process. No person, life, liberty, due process, y'all kind of that stuff, right? That's where that comes from. And so what they were saying, they being the Supreme Court and Miranda, is in order, when you look at the question, if you are being arrested by the police or placed into custody by the police, taken down to the station, or just in custody, and they're going to interrogate you, right? What process is due you? What process do they have to abide by to make it fair? And what the Supreme Court was saying is, here's the process. You read them their rights. You tell them they have a right to an attorney, that if they can't afford an attorney, that one and will can be appointed, for them. Your right to remain silent. Anything you say can and will be used against you in a court of law, right? If you can't afford an attorney, I went over that. All right, so you read them those rights. Okay, so now here's the question. So we know you're in custody when they came and got Ernesto Miranda out of his Phoenix home and took him down to the police station and put him in the interview room. We know that Miranda was in custody. Here's my question to you all, and here's this question that this next case talks about. When you get pulled over by the police on the highway, let's say you've been speeding, or let's say that you out and they want to investigate whether or not you violating the sick and shut-in rules, or you were out over this 3-day curfew, between 11 and 5, and they wanted to see if you had a legitimate reason to be out or if you were an essential employee, so they pull you over. Must they read you your rights? All right, so now hold on. Now I'm going to get to the case. All right, so this case was in 1984. It's called Berkemer versus Mccarty. An officer observed the defendant's car weaving in and out of traffic. The officer stopped him and asked him to get out of his car. The officer noticed that the defendant was having difficulty standing. The defendant's speech was slurred and difficult to understand. He couldn't. Y'all done seen him out there. You done seen all those the knucklehead shows with people getting arrested. So the defendant could not perform a balancing test without falling. The officer then asked the defendant if he had consumed any intoxicants. The defendant said that he drank 2 beers and smoked several joints of marijuana shortly before being stopped. The officer then arrested the defendant and took him to the county jail, where the defendant took an intoxilizer test. The test results were negative for the presence of alcohol. Right? So he ain't got no alcohol in, this is negative at that point. And so now you're the lawyer. And so he come into your office and say, hey, look, I got charged with a DUI. Excuse me. He said, hey, I got charged with a DUI. But it was for marijuana. I said, so, hey, man, how did they find out you were smoking marijuana? Well, I told him. What do you mean you told him? Well, he took me out the car. I was falling around a little bit. I couldn't do this and that. And he was asking me questions. And I told him I smoked a couple of blunts before I started driving. And so you start thinking about that Miranda case. You're like, hey, I remember something about that Professor Lawson on some free law school at Law Dog University. He said something about Miranda. And if you're in custody and they question you, they got to read you. Did the cop read you your rights? You say, no, I ain't say nothing to me, man. All right. So what you do, you file a motion to suppress. What's that? A motion to suppress is when you tell a judge, you file a motion saying, Judge, this was taken in violation of my client's constitutional right. What constitutional right you talking about? The Fifth Amendment. What do you mean? The Fifth Amendment says you have a right to remain silent, right? A right not to be a witness against yourself. It don't say the word right to remain silent in the Fifth Amendment. It says that you do not have to be a witness against yourself, which means you have a right to remain silent. And when he being that officer, asked my client questions about did he have any drink or any drugs that night, and he had him out the car, he was in custody as far as Miranda's concerned, and he was supposed to read him his rights. Right? Now, so let's see if y'all think that that's true. Right? So again, that's just the other facts. So the Supreme Court of the United States, it went all the way to the Supreme Court. Berkemer did. You see, when that guy was out there smoking them blunts, man, this is what I love about the law. When y'all looking at these cases and stuff like that, Berkemer ain't thinking about going to the Supreme Court when he's smoking them blunts. Little did he know this case is important. And so the fact that he was out smoking marijuana has helped a lot of people. So Supreme Court ruled two things. Because here's the prosecutor argued this. Look here, Judge, we ain't had to read him his rights. And let me tell you why, Your Honor. This is, when it was at the trial court level. So after the arrest, and remember the lawyer says, I'm going to file a motion to suppress and get this thrown out. They go to court, right? What the prosecutor said to the judge back then was, he said, hey, look here, yeah, we didn't read him his rights, and we ain't have to because this wasn't nothing but a misdemeanor, traffic stop. And so when we're talking about minor traffic offenses, where people get pulled over for speed and all that, Miranda doesn't apply. And the court said, no, Miranda does apply to custodial interrogations involving minor traffic offenses, but you got to be in custody. That's going to be extremely important in the next couple of classes, because the question is going to be what's custody. Right? And here's what they said. Routine questioning of motorists detained pursuant to traffic stops is not custodial interrogation under Miranda. In other words, under this case, this applies under the federal Constitution. Your state constitution, and depending on your state, may give you, like in Hawaii, there was a case, and Judge Foley tipped me off to this case this morning. The Court of Appeals here in Hawaii, not the Hawaii Supreme Court, last week ruled that when a person was, and Nelson, you're like this, that when a person was speeding excessively in Hawaii, and they could have been arrested for excessive speeding, when the officer pulled them over, he or she was supposed to read them their rights. I don't think the Hawaii Supreme Court is going to agree with that when that goes up. That was just decided by the Court of Appeals last week. And I'm going to tell you why. Because I'm going to get into here's what the court was saying, and you'll understand why I don't think the Hawaii Supreme Court is going to agree with that Court of Appeals either. The court stated that roadside questioning of a motorist detained pursuant to a routine traffic stop does not constitute custodial interrogation for purposes of Miranda. Now, yeah, you're in custody, but for purposes of us having to read you your rights, it doesn't amount to that type of custody. Although an ordinary traffic stop does curtail your freedom, right? You ain't free to go, right? When you get pulled over for a speeding ticket or something like that. But it does impose some pressure on the driver to answer questions. Such pressures, though, do not sufficiently impair you to exercise his privilege. In other words, what they're saying is, look, the pressure you feel when you're down at the police station and they got that light over your head, you know, and they around you, and they asking you questions about where was you at. That type of pressure, right, it's so coercive that the police have to read you your rights. But if you're just getting stopped on the highway for a traffic violation, yeah, it's some pressure there, but it doesn't amount to the pressure to where we think that you can't understand, that you still don't have to answer these questions. You don't need them to tell you that. It's not coercive. You're not being coerced into speaking. It's not violating your right to what? Your right to not be a witness against yourself. What do you mean? Your right to remain silent. It's not such a coercive environment, i.e. you getting pulled over for a ticket. That's what the Supreme Court's saying. To where they got to read you your Miranda rights. Yeah, you were in custody, but that's not the same type of custody that it takes for them to give you the Miranda when they want to question you. And so you get this question a lot. If I get pulled over by the police and I know I've been speeding, don't they have to read me my rights? No, they don't. That still doesn't mean you got to answer their questions. You can still remain silent. Look, don't get this confused. The fact that they don't read you your rights don't mean that you still ain't got a Fifth Amendment right not to say nothing. You can sit there and just look at them if you want. Now, that's on you. Now, I had clients, man. Look, I had clients, that just refuse to say anything to the police. They like, hey, they don't get them their name. I ain't giving you, they get arrested. They ain't got no ID on them. Right? Well, what's your name, sir? We just caught you trespassing. What's your name? And they look, I ain't saying nothing. Right? And they got a right to, right? So the police arrest them, and then they put them in jail under a John Doe or Jane Doe name. And so, right, so they're exercising their Fifth Amendment. You can't be punished for that. They're exercising their Fifth Amendment right. So then they come out for arraignment in front of the judge to set bond. And the judge, they kind of, Attorney Lawson, what's your client? Hey, look, he don't want to give his name. The judge turned to the client standing next to you. Hey, what's your name, son? I need to set a bond. And the guy just look at the judge like, I ain't saying nothing to none of y'all. Right? And the judge said, that's fine. Now, you got a Fifth Amendment right. Sonny, you don't have to say nothing. But I can't set a bond unless I know who you are. So you go on back in that jail and you're going to sit on down. And whenever you're ready to tell us your name, not to incriminate yourself, but just so I can set a bond, let me know. And then take him away. And then, the sheriff, deputy, whatever, come over there, haul him off to jail. Right? But here's my point. I used to tell clients this all the time. And when if you get arrested, the best thing you can do for yourself, or actually, even before you get arrested, if you commit a crime, the best thing you can do is to take a sharp knife and cut your tongue out. Cut it out. Just cut it out. Because most people get arrested, not so much for being caught in the act, but because they run their mouth, right? And when they and because of the confessions. And y'all watch that show called The First 48. Anybody seen that show called, let me see if I got any, The First 48? And they tell you the first 48 hours after the commission of a crime is important to the investigators to solve the homicide. Go watch how they trying to get that statement, man. And so again, talking about, I'm gonna end with this, talking about the Fifth Amendment, talking about Miranda, the rights you see on the cop shows all the time. It's a little bit more complicated than what you see, but it's a lot of fun. Because next class, part 2, we're gonna get into what is custody. What is custody? When are you in custody to the point where they have to read you your rights, right? Because it doesn't have to necessarily be at a police station. Now, keep in mind here, if they would have held her long, let's say that Berkemer, let's say they pull Berkemer over, and they pull you over, and they want to give you a DUI test, but the cop doesn't have the breathalyzer with him, right? The cop doesn't have the breathalyzer with him, and they say, well, I got to call for another cruiser to come here. Now, you sit there and you wait for 15 minutes. Now, the Supreme Court did say that brief detainment for the traffic stop can turn into custody for Miranda, depending on how long you're sitting there. See, a lot of times, I would get clients that would come in and let's say that the police think that there may be some drugs or narcotics inside the car and they want to get a drug sniffing dog. So they pull the client over, and then they call for the drug sniffing dog unit. And the client's sitting there for 20 minutes. The dog comes up and hits on the car 20 minutes later, and then they ask your client questions. What you got in the trunk? 5 kilos of cocaine, right? Now, at that point, you can argue, even though it's a traffic stop, it's then turned into custody because it's more than just your routine stop. Traffic stop doesn't take that long, but it can, and that's what the Supreme Court was saying back here when they said Miranda does apply to custodial interrogations involving minor traffic offenses if those traffic offenses turn out to be something that takes a long time where you're sitting there for a while. And that happens a lot to individuals. So let me see if you guys got any questions before we end the class today. Any questions? Kathy says this lawyer was right. Well, so Maya says he didn't have to read the rights because of a public safety exception, but keep in mind underneath the keep in mind this that when the person is weaving, you could be weaving for a lot of reasons. You could be weaving because you're looking at your cell phone. You could be weaving because you dropped a cigarette or something and you're trying to pick it up off the floor, or it dropped in your lap and you're trying not to burn, and so you're weaving. It doesn't mean that you're weaving because you're drunk. And so even though they have reason to believe you might be weaving because you're intoxicated, when the officer comes up to you, he can't place you under arrest. So you're not in custody. But he's kind of detaining you. Like go back to my YouTube channel when we talked about Terry stops. An automobile stop in that situation maybe is almost akin to a Terry stop. It's a brief detainment to determine whether or not you're engaged in drunk driving. And so you can always tell the officer, I'm refusing to participate in any field sobriety test. I don't want to do it, and I ain't breathing into that thing, right? And so again, so in most states, they will give you what do they call that? Your license can be suspended for failure to blow, right? You say, well, if I'm exercising my Fifth Amendment right to remain silent, I don't want to breathe into it. Doesn't that count? We'll get to that in another class, right? We'll get to that in another class. If they come to you and want to take DNA and take a hair sample, right? Is that incriminating? Is that come underneath the Fifth Amendment? We'll get to that in the next class. I'm saying that because I want y'all to understand how exciting this stuff is, man. And you can watch free law classes and not be thinking about the COVID-19 pandemic at least for an hour. So, all right. So, look, I'm going to try to get this ghetto stuff. I'm trying to up my game a little bit. It's a tuition-free university, and so I don't have all the hookups. But I did, like I said, I downloaded some apps, and you may see me throughout the week coming on. It's just going to be tests to see if I know how to work it, because I don't know how to do it without. Anyway, so hopefully it'll bring a better quality video. It'll allow me to not have to use this screen, and I can flip stuff up and in and out, sort of like what you watch on TV, and we can have more fun learning. But I enjoy teaching you all. I enjoy teaching our students here. I actually love this stuff. Rodney wants to know, can he get a credit for this? Yeah, you get a credit for this. Yeah, a free law dog. It's going to be, y'all credits is going to be little dog bones. You establish enough bones, you get to graduate before the COVID-19 pandemic is over with. All right, so again, I'll see you all. I'll post, hopefully, I think I'm going to come back and do one on Thursday, but I'm gonna try to practice on this new format. But put it in there. Any suggestions you want to know about any other thing doing with criminal law. Don't be talking about Lawson. Can you start talking about the new tax code? Because I ain't doing that. I don't know nothing about it. All right. See you all in the future. Hey, take care of yourselves. Take care of each other.